I call the Honourable Phil Goff.
Mr Speaker, I'd like first to thank the Minister for making an early copy of the bill available to myself and Jacinda Ardern and for taking the time to consult on it. I've got to say, Mr Speaker, that is a rare practice amongst the Minister's colleagues, but one which I would encourage, particularly when we're looking at controversial or potentially controversial legislation that has quite dramatic impacts on the rights of a small number of individuals, but in order to protect the rights of a much larger number of individuals. Mr Speaker, Labor is supporting the introduction of this legislation. Labor has consistently supported legislation for many years, as long as I can remember in fact, which is evidence-based, which is likely to be effective and which is designed to protect the rights of those who deserve to be protected. And in particular, in this piece of legislation, I'm thinking about the rights of our most vulnerable citizens, which are our children. Mr Speaker, we don't offer that support lightly, and we don't offer it lightly because when I received a copy of the report of the Attorney-General, Chris Finlayson, under the Bill of Rights, he says this in the Bill of Rights vet: I have considered this bill for consistency with the Bill of Rights Act 1990. I conclude it appears to be inconsistent with the rights against the imposition of retroactive penalties and double jeopardy, which are affirmed by Section 26 of the Act. Whenever we have a piece of legislation in front of us in the House that is found to be inconsistent with the Bill of Rights, that means that we have to give it particular attention, because we are cutting across rights that we would normally extend to all New Zealanders. The right not to face double jeopardy, the right not to have penalties imposed retroactively. Because of that, it will be incumbent on those of us that sit on the Law and Order Committee to scrutinise this legislation very, very carefully, to ensure that we do get the balance between the absolute right of our children and others not to be subject to preventable sexual attacks and the rights of all individuals to not to face, as I said, double jeopardy and retroactive penalties. Mr Speaker, the motivation and the timing of this bill is because a particular individual is due for release into the community next year following the expiry of a 10-year extended supervision order. I have been following the history of this individual for 20 years. The individual's name is in the public arena. His name is Lloyd McIntosh. Lloyd McIntosh was one of 35 people released by Jenny Shipley when she amended the Mental Health Act in 1993 from the Lake Alice Mental Hospital. The difficulty, however well intended she might have been in updating the Mental Health Act, the difficulty is that the result of the national government's legislation at that time was to put out into the community 35 people with extensive histories of sexual offending against children without any supervision whatsoever over how they might behave in the community. And I found out about this through a charge nurse at Lake Alice Hospital. His name was Neil Pugmire, and I again pay tribute to him in this House because he had the courage that is the courage of a whistleblower who says, this is wrong, I must speak out to protect the public, and in doing so lost his job and was discriminated against by the then national government. The truth is, Mr Speaker, that Neil Pugmire was proven right and the national government was proven wrong. The particular individual that I talked about, Lloyd McIntosh, even his mother opposed her son's release into the community, believing that he was not capable of changing his behaviour. Lloyd McIntosh had a condition known as a personality disorder. It's not a mental illness, but it is something that meant that for an individual like him with an IQ of around 70 and an understanding probably equivalent to that of a 9-year-old, that whenever he was released and whenever the opportunity arose, he would offend. And the history of his offending is too dreadful to go into in this House. Needless to say, one of the rapes that he committed was against a 23-month-old baby who almost died, a 6-year-old child and an intellectually disabled woman. I opposed the releases of those individuals when I was in opposition. In government, I introduced legislation in 2003, the Extended Supervision Orders legislation, designed to protect the community against people like Lloyd McIntosh. And again, in opposition, I support the government and the Minister in what she is trying to do here. I want to quote, Mr. Speaker, from what I said when I introduced the Extended Supervision Orders Bill in November 2003. Quote, "I do not lightly promote legislation which in part may conflict with the Bill of Rights requirements. However, in this instance, the risk posed by such offenders is real, and the vulnerability of our children and the need to protect them must be our paramount consideration." End quote. I said that a decade ago, Mr. Speaker, and I stand by that comment now, and that is why I'm prepared to extend, on behalf of the Labor Party, our support to the Minister in this instance. Mr. Speaker, the Extended Supervision Orders have been used to manage a relatively small number of child sex offenders who have the high risk of causing serious harm following their release from prison. The orders last currently up to 10 years beyond the end of the sentence, when corrections can continue to manage offenders. The reason why we are looking at this piece of legislation today is that that 10-year period has expired for the people who were the earliest recipients of the Extended Supervision Orders, and some, at least of them, continue to pose a risk. Most, after 10 years of extended supervision, won't. Some will, and those who do will pose a serious risk to the safety and well-being of our children. This bill therefore enables the orders to be renewed. It also expands the scope of the orders from high-risk child sex offenders to include high-risk sex offenders against adults and very high-risk offenders at risk of violent offending. The numbers, sir, are relatively small. In the regulatory impact statement, probably between 29 and 41 offenders will be placed on extended supervision orders each year because of this legislation. 25 to 30 of them, the vast majority, will be high-risk sexual offenders against children. 4 to 9 of them will be high-risk offenders against adults, and 1 to 2 will be at high risk of violent offending, not over a period of a year, but over 5 years. It's a very small number, Minister, and maybe it is necessary for, as you point out, 1 to 2 people every 5 years, but we'll be looking at whether this is a category that does justify being added to the bill. It's not a cost-free exercise, Mr. Speaker. It costs on average $27,000 per offender per year to keep them on an extended supervision order. And wait for it, those that are subject to intensive management, which will be for the first 12 months of the sentence, the cost of that will be approximately $300,000 a year. Now, for those that believe that is excessive, it might be a high cost, but just consider the cost to a child who is sexually violated in a way that some of the victims of Lloyd McIntosh were violated. And then, sir, I believe that that sort of cost is and can be justified, Mr. Speaker. There are safeguards in the legislation. They'll be subject to mandatory reviews by the court, so it will be judicially and independently reviewed by the court. It's an important safeguard. They'll be subject to people subject to the orders will be subject to them only as long as the risk of serious harm to the public from the offenders warrant it, and the parole board will have to review every 2 years any high impact conditions imposed on the offender. Mr. Speaker, I believe that this legislation is justified. Consistent with our past position, the Labor Party will be supporting it. But because of the effect on rights guaranteed under the Bill of Rights, I think it really important that the Law and Order Committee examines these provisions very carefully to ensure that at each point of the legislation we have the balance right between protecting the rights of individuals against high-risk offenders and the rights that every New Zealander enjoys under the Bill of Rights.
I call the Honourable Member Jackie Dean.